Military Matters volunteer attorney Jill Olson of the Olson Law Firm will provide important information about your rights as a debtor and what creditors can and cannot do. Jill practices in the areas of bankruptcy law, collection, foreclosure, and is a litigator in consumer, commercial, and bankruptcy law. She is a former law clerk for a judge with the Missouri Court of Appeals, Western District.
I have been a creditor's attorney for over 20 years. During that time, I have sued thousands of people like you who have unpaid debts. But I'm here to tell you some things you may not know and hopefully give you some tools and information to help handle things if you end up in a situation where you have to deal with a debt collector or an attorney. Just because you owe a debt does not mean that the creditor has the right to turn your life upside down. You have the right to remain in control. The primary law that protects debtors from creditors is called the Fair Debt Collection Practices Act, or FDCPA for short. And this law has some powerful tools to protect you and to prevent a creditor or debt collector from bullying you. If a creditor or a debt collector calls you, they cannot harass or call you names. They cannot harass your family members. They cannot call before 8 a.m. or after 9 p.m. They cannot call if you are represented by an attorney. They cannot call if you tell them to cease and desist, and they cannot threaten you with being put in jail if you fail to pay. If a creditor or a debt collection agency sends you a letter regarding a debt that they allege you owe, you have the right to dispute the debt. You also have the right under the FDCPA to demand that they cease all collection on the debt until they provide you with specific information. This includes support for the amount claimed, proof that the debt is your debt, including copies of any documents they allege you signed, and the name and address of the original creditor. If the creditor or debt collector fails to respond to your dispute, the FDCPA allows you to sue them for violating the law. Now, if you live in Missouri and you are behind on your house payment, the mortgage company may not take your home without first following certain rules. First, they are required under Missouri law to send you a notice of default and right to cure, giving you the amount necessary to bring the account current and a due date. If you do not pay the amount owed by the due date, the mortgage company will then request a trustee sell the property at auction. The trustee is required to mail a notice to you 30 days or more before the sale. The trustee is also required to publish notice of the foreclosure sale in a local newspaper, either for 20 straight days or once a week for 4 weeks, depending on the county. Now, this notice will state the date, time, and place of the sale. The trustee will then auction the property on the date and time indicated. Before the property is sold, you have the right to bring the account current, dispute the amount due and owing with the trustee and the mortgage company, or file a Chapter 13 bankruptcy to stop the sale. Now, if you're behind on a car loan, a lender cannot repossess your vehicle without taking certain steps. If you are 10 days late in making your payment, a lender must send you a notice of default and right to cure. Again, you have the right to bring the account current within 20 days. If you do that, then they cannot repossess the car. But you're only entitled to 2 of these notices over the life of the loan. So if you default twice and cure twice, and then you default a third time, they are not required to send you a notice. They can just come get your car. Also, a lender is only legally required to send the notices to the last address that you provided to them, either in writing or on the phone. So if you do not keep your lender informed of your current address, you are only hurting yourself, because you are not going to get the legally required notices. Now, if the lender repossesses the vehicle because you failed to cure the default, they have to send you a notice of plan to sell property. This notice gives you another 20 days to bring the account fully current and regain possession of your car. If a creditor sues you and you have to go to court, you have the right to ask for evidence as to why you owe the debt. This request must be in writing and mailed to the attorney for the creditor. You will also need to file a notice with the court that you made this request. My best advice if you are sued is to hire an attorney. You may think that you can't afford one, but you are at an extreme disadvantage if you try to represent yourself. Now, if you lose at trial and you're being garnished on the judgment, you have a right to claim certain exemptions to shield your assets from creditors. In Missouri, if you have children under the age of 21 living with you whom you support, you can file an exemption and claim head of household. This reduces the amount that can be garnished from 25% to 10%. If you lose at trial or you agree to make payments and you can't pay anymore, you have the right to file bankruptcy and possibly eliminate all or most of your debt. For a free guide on surviving debt, go to the National Consumer Law Centers at www.nclc.org. There you will find consumer education brochures, consumer debt advice, and a book on surviving debt. If you believe that a lender or a debt collector has violated your rights, you can visit the Consumer Financial Protection Bureau website at www.consumerfinance.gov and submit a complaint, ask questions, or seek additional information about how to protect yourself financially. I hope that you are never in this situation, but if you are, I hope that the information I've provided is helpful to you.